Divorce Basics, How the Divorce Filing and Litigation Process Works, Part 1. Hello, I'm Ed Heck, and I'm a Georgia divorce and child custody attorney. I'm also a divorced single father of 2 children. I personally know what it's like to deal with these kinds of family law issues, and I am passionate about helping others get through them as well. Today's topic, the basics of divorce, how the filing and litigation process works, will be presented in 2 parts. Part 1 will provide a basic explanation of the divorce litigation process. Part 2 will address what happens if parties are not able to resolve their issues by agreement. Do you realize that next to the death of a loved one, a divorce, also known as the dissolution of a marriage, is the most difficult experience most people will ever go through? The statistics say that nearly half of all marriages will end this way, but yours was supposed to be different, right? Now your marriage is ending, you're facing the idea of life as a single person or a single parent. It can be overwhelming, scary, gut-wrenching, disappointing, and embarrassing. All those hopes, dreams, and plans, everything just dashed. You're wondering what your rights are, what a divorce costs, what will happen to your children, what are divorce proceedings like, what happens with your property, your money, your retirement savings, your home, and more. Preparing for divorce can seem overwhelming. It's too much to deal with alone, and you need someone who will guide you through the complex legal maze to a brighter outcome and a new future while protecting your rights. Unfortunately, it's not as simple as filing some divorce paperwork. I know how you're feeling because, as I mentioned, I've been there myself, and I would like to help you get through your divorce too. Part 1. Let's start with an explanation of the divorce litigation process in broad terms. The basic process of divorce litigation usually goes something like this. One party files a complaint for divorce and the other party files an answer, typically with the assistance of a lawyer. Next comes the discovery process, whereby each party can serve the other side with questions, either orally or in writing. Each can ask the other to produce documents, depositions might be taken, and the parties might be required to either admit or deny certain allegations. When the questions are asked orally, that happens during a deposition. Maybe you've heard this term or heard the word deposed used to describe the process of asking someone oral questions under oath. When the questions are written, they're called interrogatories, and they too must be answered under oath. That means that the person is swearing that their answers are true, and there can be penalties for providing answers that are later found to be untrue. The parties can also ask for documents such as pay stubs to validate income, tax records, lists of property that the parties feel that they should be entitled to keep after the divorce, and many more. And finally, parties can ask each other to admit or deny certain written allegations. This process is referred to as requests for admissions of fact. Once again, the responses are made under oath. The court may require the parties to attend a temporary hearing and determine matters on an interim basis while the case is pending. The temporary order may cover such issues as temporary custody of the children, temporary possession of the marital home, temporary child support, temporary spousal support, even temporary custody of a pet. The reason for the temporary hearing and temporary order process is that there is often a good deal of tension between the parties when they are facing a divorce. It can take months or even years to reach final resolution in a case, and that's usually too long for most people and their children to live in a state of limbo. So one of the parties may request the temporary hearing, or the court may require it on its own initiative. Sometimes the court may order the parties to attend mediation, or the parties may voluntarily agree to try mediation as a form of alternative dispute resolution. Mediation can occur before the temporary hearing or after it. It's been my experience that when the parties are motivated to resolve their case, at least some of the issues can be worked out in mediation, even if not all of them. For example, the parties may be able to work out their custody issues and property division, even if they can't work out the financial settlement. In this case, a trial would only be needed on the one issue of dividing the finances, things like debt and retirement accounts, for example. In some cases, there may not be a mediation or nothing is resolved at mediation, and the parties have to take their entire case to trial. Although it's very rare for a domestic case to have a jury trial, it is allowed. However, a jury cannot decide the issues of custody and visitation. Only the judge can do that. But the jury can divide the property, the finances, and determine spousal support or alimony or child support. Regardless of the path and length of the case, eventually a final decree of divorce is issued by the court, formally ending the marriage. If you would like additional information about what happens when parties are unable to resolve their issues by agreement, please watch Part 2 of Divorce Basics, How the Filing and Litigation Process Works. I deal with these issues all the time in my family law practice, so call me at the number you see on this screen and we'll talk about your questions. You can also visit hechtfamilylaw.com and fill out the Contact Us form. Thanks for watching. I'm always happy to speak with you, and please click like or share if you're seeing this video on Facebook or YouTube so that others will see this important information too.